Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Good morning. We have one case on our submission schedule this morning. It's 2729, State of Texas versus Hollins in his official capacity as Harris County Clerk from Harris County and the 14th Court of Appeals District. We're ready to hear argument from the state.
May it please the court, Mr. Hawkins will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
Thank you, Mr. Chief Justice, and may it please the court. The Harris County Clerk's plan to send unsolicited applications to vote by mail to every registered voter in Harris County, the vast majority of whom are not eligible to vote by mail, is ultra vires and therefore unlawful. And that ultra vires action inflicts irreparable harm on the state, both as a distinct and cognizable sovereign injury, and also by increasing the likelihood of voter confusion on the eve of a national election.
Mr. Hawkins?
Yes, Justice Guzman.
Do you agree that non-governmental organizations and individuals can distribute applications for mail-in ballot? And to your knowledge, has that occurred?
Well, Justice Guzman, we have no ultra vires claim against a private organization that is sending out such ballots. And indeed, Chapter 84 of the Election Code contemplates that that might happen. I believe, I'm sorry, Your Honor.
Yeah, so I'm going to get to the third part of the question and then let you finish your answer. It seems that you agree that that is occurring. Is there any evidence that such mass distributions have resulted in voter confusion or fraud?
Well, Justice Guzman, I don't believe the record below speaks to that. But if I were to step outside of the record, I think that those types of mailings are much less likely to result in voter confusion than what Mr. Hollins anticipates doing here. And that's so for a couple of reasons. Number one, the proposed mailer that Hollins would send out is individually personalized to each voter. It includes a unique barcode, and it has some of that voter's information filled out on the form and, of course, on the envelope. I don't believe that's true from what I understand of some of the private mailings. Then on top of that, Justice Guzman, I think there's something fundamentally different about a governmental entity bearing the imprimatur of the government, sending you something, saying, here, take a look at this. That's, I think, distinguishable from the reams of junk mail that we all receive in our mailboxes every day. We know in lots of contexts that people react differently when it's an officer of the government telling you to do something than when it's just a private entity. And so for that,
do you believe that the prominent and detailed instructions on the advisory would ameliorate any concerns that voters will be confused about whether they may vote by mail or not? Because I see your point about the imprimatur of the government doing that, but do you think that ameliorates any concerns?
No, Justice Guzman. I think that what's on that mailer has no bearing at all on the ultra vires inquiry. All that matters is that the clerk intends to send an actual application. It doesn't matter what else is in that envelope. That is ultra vires. In any event, the information that's on the mailer, I think doesn't speak to the nature of the harm that the state is alleging here. We are alleging a distinct sovereign injury that is inherent in any ultra vires action by a subordinate governmental entity. Now here, we've got a separate harm apart from that, a concrete harm in the record below that there is a likelihood of voter confusion. And I think the mailer that Mr. Hollins proposes backs that up. To be sure, portions of that mailer are not inaccurate, but he doesn't give a full description of what this court held back in May in the In Re State case. It's true that this court gave some indication in Re State that a voter might make the initial determination as to whether they're suffering from a disability. But this court in that case had a crucial second component to the analysis, which is the likelihood of injuring the voter's health that comes with in-person voting. The mailer speaks to that not at all. And so I think there's a very real concrete possibility that the mailer will only add to confusion. Again, we don't need that in order to prevail, but that confusion is there.
So Mr. Hawkins, if the clerk were to send out the exact same document to every registered voter in Harris County, but if at the bottom of the document, instead of having the application, it provided a web link that they could use to click on and pull up an application, even with their name and distinct number on it, and print it off, and or provided addresses of places they could go to pick up one, would he be acting ultra vires?
So Justice Boyd, the analysis there would be the clerk would have to point to a statute that authorizes him to do it. So to answer your question, I guess I'd want to know what statute he thinks authorizes that. Now he's identified 5 statutes.
Excuse me, Mr. Hawkins, really in relation to that, it's my understanding that the state is not objecting to the clerk sending those applications to all persons over the age of 65. Is that correct?
Well, Justice Lerman, that's already happened. That happened earlier this year. And of course, we cannot bring an ultra vires action to enjoin something that's already happened in the past.
Was there an objection to that? That happened, I believe, what, in July?
I believe it was, I'm sorry.
This past summer. So was an objection made by your office as to the ultra vires nature of that act at the time?
Your Honor, it was earlier this summer, and we did not bring any ultra vires action to enjoin that conduct. Of course.
And is there a statute that authorized that?
I don't believe so, Your Honor. In fact, I believe that conduct would be ultra vires. But the crucial point here, Justice Lerman, I think, is that because the state does not bring an enforcement action as to every ultra vires action taken by counties around the state, does not make this conduct somehow lawful. This action that Hollins contemplates is a serious affront to electoral integrity on the eve of a national election.
But that's no basis for us to strike it down. If it creates a risk of fraud or a risk of confusion, or if it is a serious affront to the integrity of the election, you agree that doesn't give us as a court a legal basis to prohibit it. That's
Your
not
Honor,
the issue here.
I'm sorry, Justice Boyd, I'm not sure I heard the last part, but I think I got your question. The answer is that we need to point to some ultra vires action, and here we've pointed to one. Nothing authorizes him explicitly or impliedly to send out these applications to vote by mail. And
But
that's
if something did, we would have to allow it even if we thought it was a serious affront to the integrity of the election process or would promote fraud. Do you agree?
Well, Justice Boyd, I can't think of a basis. If Mr. Hollins is doing exactly what the legislature has prescribed, if this court thought that that were bad policy, it would nevertheless be the law. And I don't know of a way to enjoin that action. But of course, that's not presented here because the 5 statutes he has identified don't expressly give him this authorization and don't impliedly give him this authorization. And
I'm sorry, if I may, Justice Guzman, I just have one quick follow-up. So one of those statutes is 83.001 is kind of the primary statute that he refers to, he relies on, which incorporates the one of the other statutes. But in essence, that statute authorizes him to, quote, manage and, quote, conduct early voting. And I've read all your briefing on that. My question is there anything that an early voting clerk can do to manage and conduct early voting other than specific actions that
the code's other provisions expressly mandate or authorize him to do?
Of course, Justice Boyd. There certainly are, and let me give Your Honor some concrete examples. I think that the power to conduct early voting includes the power to make sure that the air conditioning in the room is set to a level at which people can enter the room to engage in early voting. The statute doesn't say anything about air conditioning, but I think that's indispensable to carrying out that duty. Another example, 84.012 gives the clerk an obligation to send an application to a voter on request. I think included in that, what's necessarily implied there, is the power to buy stamps and the power to either hire somebody or buy a printer in order to print off those applications such that they can then be stamped and mailed to the voter. Now that statute doesn't say the word stamp, it doesn't say the word printer, but in telling the clerk he has to do these things, it is indispensable this is the term that Bizios used, that he buy stamps and get a printer in order to effectuate 84.012. But our point here is that what he seeks to do in this election, to send out unsolicited applications to vote by mail, is a far cry from any of that. And indeed, the statutes he cites, 1.010, 84.012, 84.013, these statutes all involve the word request. They're telling the clerks what to do in the event that they receive a request. And of course,
what about, Mr. Hawkins, what about the provision that talks about making applications readily and timely available? How does that fit within the idea that the clerk cannot mail them and thus make them readily available?
So a couple of answers, Justice Bland. Your Honor is referring to 1.010A, and that does indeed speak about making available. I think the fairest reading of that does not encompass an unsolicited sending out of materials. If I tell my boss that I'm available to meet this afternoon, that doesn't mean that I'm going to go to his office and check in on him. The word available, the idea behind that word is that the clerk has to make it such that the voter can avail himself of these forms. That's putting the onus on the voter to do something. And here the voter is doing nothing whatsoever. I think it's also worth noting I'm sorry, Justice Lerman.
Mr. Hawkins, does the state object to applications being made available online?
Well, Justice Lerman, again, I'd want to know what statute Mr. Hollins thinks authorizes that. If he wants to make them available online, he's got to point to a statute that authorizes him to do that.
What about the statute we were just discussing?
Your Honor, I think that issue hasn't been briefed. I think that make available certainly means keeping these forms in the office. I think the online question is much closer. At the very least there, the voter would have to go to a website and click on something. That does seem like it's a request within the meaning of 1.01B. But I want to stress that the court doesn't have to decide these close questions in this case, because the action that Mr. Hollins actually intends to undertake is really not a close call. And just to follow with Justice Bland, I think it's worth noting, Justice Bland, that in 1.010B, we once again see that word request. And it's been the law for decades that we read statutes holistically in accordance with the company that they keep. And we see in that sense that 1.010 is tied in with 84.012 and 84.013. They all hinge on the idea of request.
Mr. Hawkins, how does your theory... Go ahead, Justice Blackwell.
Thank you. Counsel, the relief you sought in the trial court was specific to voters under 65, as I recall. I understand that your legal argument in this court is not specific to voters under 65, but does that remain the relief that you seek?
Yes, Justice Blacklock, the applications for voters over 65 have already gone out the door. And so it would not be permissible for us to seek to enjoin something that has already happened.
Justice Busby.
Thank you, Chief. Mr. Hawkins, your position on the nature of the county clerk's authority and the need for what they're doing to be indispensable, how does that affect some of the examples that we've been seeing from in the amicus briefs, for example, from the Dallas County Clerk expressing concern that they have a property fraud alert system, they have use of social media to connect individuals for whom they hold funds in trust. What's your position on this is going to have ramifications outside this case, and so how do we tread that line to be sure that the clerks can continue to do as they see it, good customer service?
Sure, Justice Busby. I think the best way to resolve that is to stick to what has been the law for just about a century, which is that in order for a clerk to do something, the clerk has to point to a specific grant of power. And all those other things that clerks do are surely authorized if the legislature has given them the power. Mr. Chief Justice, I see I'm out of time. May I finish my answer?
Yes, you may, General.
The clerk, I think the court's holding, Justice Busby, should be that the clerk has to point to a statute to determine whether that action is authorized. And if the clerk has pointed to a statute that expressly or impliedly authorizes the action, then the clerk can do it.
May I ask just a follow-up question to that, please?
Justice
Thank
Lemon.
you. Thank you, Mr. Hawkins. And that is, if there was not specific statutory authority for the clerk to send an application to someone who had requested it, would they have the authority to do that implicitly?
I'm sorry, Justice Lerman, I'm not sure I caught the beginning of part of the question.
So if there was no statutory authority for the clerk specifically to send an application to someone who had requested it, would they be able to do that with implicit authority?
Oh, I think I understand Your Honor's question. I guess I want to know what statute the clerk is pointing to. If there's no statute that authorizes a clerk to send applications to vote by mail to individuals, then I would think the clerk couldn't do that. And I don't know what statute would imply that power. I'm not aware of one, although if the clerk were to point to one, we'd have to evaluate that statute accordingly.
Hey, I'm sorry, Chief. I just have to follow up on that answer, Mr. Hawkins. So in other words, if there were, I mean, you're very familiar with these statutes by now. If there were no section 84.012, if that were not in there at all, based on everything you've seen in the election code, it would be your position that a clerk would not be authorized to mail an application to someone who requested it. Is that correct?
I don't think that's quite right, Justice Boyd. I think we'd want to look at 1.010B. That talks about furnishing forms in a reasonable quantity to a person requesting them. So if you were to wipe 84.012 off the books, I think 010B would do the job.
Any other questions?
Chief, I have one.
Yes.
Yes, Chief, I have a question. Mr. Hawkins, have these ballots and applications, have they already been printed up?
Your Honor, I do. If Your Honor is asking about the current state of affairs, I don't know the answer to that. The record in this case was frozen a couple of weeks ago in district court. I do not believe they had. Indeed, I believe in district court, the county was representing that it would take some time to do that. But the record doesn't say, and I don't know the answer to the state of affairs today. I think that my colleague on the other side, Ms. Hayes, might know the answer to that.
Any other questions? Thank you, General Hawkins.
Thank you, Your
We'll
Honor.
hear from the Harris County Clerk.
May it please the court, Ms. Hayes will present argument for the respondent.
Thank you. The state's ultra vires argument has no application in the context of the election code or in Texas's system of conducting elections. And the state's aggressiveness in pushing their ability to second guess every act of a local government official, and specifically an early voting clerk that is not specifically outlined in a statute, would in effect, in practice, shut down the conduct of elections, shut down, as the Dallas County Clerk pointed out, their everyday functioning and customer service. And it runs contrary not only to the specific language of the election code as the legislature has chosen to write it.
Excuse me, I'm sorry to interrupt, but did I understand you to say that there's nothing that the clerk could do that would be taken as acting in an ultra virus manner? Is that what you said?
No, I don't mean that at all. I would point the court to section 31005. That's the backstop section for when the state may step into the conduct of local elections. And that provision provides that the Secretary of State, if it sees a local government authority abusing its power and impeding voting rights, the SOS may then ask that local authority to stop. And if the authority doesn't, ask the Attorney General to go file a lawsuit to force the local government authority to quit violating voting rights.
Ms. Hayes, I'm not seeing your video on my screen, so I'm not sure if that's on. And but I do have a question for you. There you are. I do have a question for you. How does mailing out unsolicited voter applications constitute management of early voting?
It constitutes very needed management in the context of, particularly in the context of the pandemic we're undergoing. You know, as everyone here has voted before, voting places can be crowded. So our election authorities around the state have a hard job in front of them. How do we conduct an election in a manner that's safe? And I'll, by way of explaining that, give an example of an act the Harris County Clerk has taken that's not specifically allowed in the statute. He has moved the main voting election office from a crowded building in downtown Houston to the NRG Center, so that the staff may socially distance, so that the early voting ballot board and signature verification committee, which is comprised of a bipartisan group of temporary workers appointed by each party, can socially distance. And also so there can be a massive voting center so that the voters can socially distance.
But it still seems to me that mailing out these mass applications isn't management, it's just blanketing of applications. And in any event, the election code already specifies how application ballots will be managed by furnishing them on request. So I'm still not understanding how that mass mailing is management as specified by the election code.
I was getting to that, Your Honor. By increasing the ratio of voters who vote by mail, you decrease the bodies that come into the polling place. And Judge Larriman had a question earlier about the mailers 65 and up. Those have gone out 2 times, not once. They went out first in June for the July runoff election. And that was very successful. And there is in the record a spreadsheet of what were the sources of applications the clerk's office received. And the largest category by far was that mailer. The voters liked it. They used it over the ones campaigns sent out that don't have detailed instructions and user-friendly instructions. And it was also, back to management, designed in a way where it was much quicker to process by the staff. That pre-printing and specializing, then we know it's likely only eligible voters. That's double checked when they come back in. There's a barcode.
Does the clerk's, Ms. Hayes, does the clerk's general management power that you are alluding to, would it allow the clerk to modify the ballot to include straight ticket voting, for example, under the theory of general management, and that would take a voter less time in the polls?
It would not, because the clerk's general management powers are bounded by those sections in the election code that may specify duties or prohibit other actions, and also bounded by voting rights. So there are some sections that set the floor. 84012 is one of them.
Can I ask you a question, Ms. Hayes? Before you leave that point, as a matter of statutory construction, doesn't a specific provision like the one governing applications for mail-in ballots control over a more general provision regarding management of absentee voting?
As a general proposition, yes, but you still have to read the code as a whole and look at its overall architecture. 1010, which is in Chapter 1, the general provisions governing the code, includes that language that Justice Bland referred to, readily and timely available. That's very broad. And it certainly has, I would think, a different application in the context of a pandemic. I will add, though, I think the clerk does have the right to mail these out in a normal election. It helps make the election run more smoothly.
So,
And
so the pandemic really has nothing to do with it.
the pandemic makes it all the more important that this be done.
Yeah, but
This isn't just a matter of voting rights now, it's a matter of public health.
what if the clerk had a partisan motivation? What if a clerk said, you know, I'm going to send these mailers to one part of the county that I think is likely to vote one way, and not to another part of the county that's likely to vote another way?
That's when 31005 kicks in. If the voter, if an elected official is making it easier for one segment of the population to vote versus the other, then voting rights kick in.
But if Harris County wanted to do this and another county said, no, I think this favors one party or another, and so I don't want that to happen in my county, would that be all right?
I think the question we should all be asking ourselves is why the other 253 counties is not doing this, and why the Secretary of State is not encouraging it, because it makes voting safer for voters and for election workers alike during this election. It also makes voting practically available during this election. And one of the duties of election clerks and election authorities is to think about the individual nature of voting rights. It's not a collective right, it's an individual right. And that means to make it readily and timely available, that's readily and timely available for everyone, not just voters who have a printer at home.
Council, there are several states that are sending vote by mail applications to every voter, states around the country. Are there any states that you're aware of where the decision whether to do that is up to the local, to the discretion of local officials?
I do not know in specific. I would imagine so, because it is common in other states that local officials have a lot of management authority over elections. And that makes practical sense. You don't want the Attorney General deciding which gymnasium is the best polling place. And I'll bring this back to the overall.
Well, you might want statewide uniformity in something like the mailing out of ballot applications to every single voter. It's my understanding that most of the states that are doing that, are all of the states that I'm aware of that are doing that, are doing it at the statewide level, as opposed to just a patchwork of different policies in different counties.
I agree that we want it, but I disagree that the election code allows it in this context. The Secretary of State could encourage it, but it's up to the local election authorities to decide how to manage and conduct the election.
So on that point, the code of course, it doesn't just directly say that the clerk manages and conducts the election. It says that the clerk has the same powers as a presiding election judge. And then you go to the provision about presiding election judge, and it says that that person, the presiding election judge on election day, conducts and manages the election. So the code analogizes the early voting clerk to a presiding election judge on election day. What power, I mean, there are thousands of presiding election judges on election day. What power that a presiding judge on election day could validly exercise is analogous to the clerks sending out applications to every single voter?
Well, I'll say an easier way to explain that relationship between an early voting clerk and a presiding judge on election day is that the presiding judge on election day has the power of a district judge in terms of managing the conduct of the polling place itself, i.e. throwing out people who are disruptive. And the early voting clerk has that for early voting. Now, for the overall management and conduct for the election, that exists, I think, in different portions of the election code, in that the powers to select polling places, the powers to determine hours. This is another place where the statute sets the floor that every local election authority has to follow, and they can add a ceiling. For example, early voting places have to be open so many hours per day for so many days, but individual counties can extend that. And it may make, and while uniformity is a good idea, I'm pretty sure Loving County does not need, Loving County does not need 24-hour polling places, but Harris County is doing that this time to again spread out the voters and also allow those shift workers who work during the day a better opportunity to vote during early voting or vote at all.
Ms. Hayes, the amicus argue there's no proof of rampant or significant voter fraud, but you'll agree any fraud dilutes votes. Is even one fraudulent vote acceptable?
Fraudulent votes aren't acceptable, but the act of giving someone an application doesn't increase fraud. I mean, our election code, and this is in an amicus we just submitted in another matter, lays out layers of checks. Those applications come back, the staff checks again, that person is eligible to vote. The ballot goes out, it comes back. Then it goes to the bipartisan committee of the early voting ballot board.
Does it create circumstances, though, that might be ripe for harm that can't be remediated? And if so, should courts just let it happen? Does it create the circumstances for that, the environment?
An application going out with instructions the state already conceded in the trial court were laudable and accurate does not create any more opportunity for fraud than the mailers that are ubiquitous out there. And there are samples in the records you can see from different campaigns.
Ms. Hayes, what is your response to the argument that they are confusing these applicants?
Which are confusing, Harris County clerks or the campaigns?
The clerks.
It's the opposite. And I think I would surmise one of the reasons it was popular with voters in June is because they give clear instructions and the campaign's mailers do not. The Secretary of State.
Hayes, do you agree that with the Solicitor General who said that the instructions don't say anything about the requirement of an increased risk of injury to the voter by voting in person?
The instructions that are on the application are quite extensive. They quote without quote marks the statute itself. They paraphrase this court's ruling.
You disagree with that characterization?
I absolutely disagree with it. And the court can see for themselves in the mailer that's in the record.
And back to Justice Guzman's question, does the fact that the mailer sent by the county official tracks the individual identity of the voter and makes the voter less anonymous in exercising his or her right to vote, is that something that could increase potentially voter fraud or coercion?
It decreases it because when that application comes back, it has that voter's signature and we can compare that with the signature on file. And that happens with everyone that does come back.
Ms. Hayes.
Has that continued to track is that identifying information continued to be tracked as the ballot comes in?
I'm not sure I quite understand your question, so sort of walk through how it would work. The application would come in with the signature, and let's say some nefarious fraudsters picked up a stack of these and signed a bunch of them and sent them in. That would instantly not work because the signature on that application would not match that for the voter whose name and voter ID number is pre-printed on that card. Once the office confirms that they are in fact eligible voters and sends the ballot back out, it's disconnected from that application that came in, if that makes sense, within the data system. When it comes back, then it goes into the normal system with the early voting ballot board and the signature verification committee. And once that voter is determined to be eligible to vote, and it is in fact that voter, their signature is checked again, then the ballot is disconnected from the carrier envelope and put in the stack of ballots that have been confirmed to be eligible to be counted.
Ms. Hayes, I'm sorry, go ahead, Chief.
Ms. Hayes, you rely on section 32.071 as it applies to judges, but it would apply to early voting clerks as well. It talks about the management and conduct of the election at the polling place. Mm-hmm. Is that last phrase, at the polling place, a limit on the management and conduct?
You have to read it in conjunction with 83001, that the early voting clerk shall conduct the election. Conduct is a broad word, and it includes all those things from renting polling places, identifying them, making sure those polling place locations do not favor one party over the other or one part of town over the other, determining how much staff. For example, the early voting clerk made the decision to increase the size of the early voting ballot board so that there would be ample staff to manage the increased number of ballots.
So in your view, 32.071 is more limited?
I'm sorry, is more what?
Limited.
Not necessarily. I think you have to read the code as a whole, and you have to also read this code and its provisions in their constitutional context of the balance of powers between state and local governments, which the amicus brief from Fort Bend County does an able job addressing. And you also have to read them in their historical context. And as I'd like to emphasize, voting rights are different. You can't read these statutes outside of the context of this most fundamental of civil rights. And this court's
Let me
precedent
ask you about the constitutional context that you mentioned, because you mentioned that private parties are sending out mailers like this as well. And of course, in our constitutional system of government, private people and organizations are free to use their money as they wish in general, and anything that's not prohibited is going to be permitted. And in fact, some things are given special protection, like political speech. But when you switch over to the public realm of government, we generally have government of limited powers, especially derivative sovereigns like counties that are spending public tax dollars. And in that environment, the presumption is generally the other way, that anything not permitted is prohibited. So what's your response to that view of it? How is, if the background presumption for county officials is that they need express permission, or it's necessarily included within something that they're given express permission to do, with that background presumption, what do you think are the best statutes for us to look at to say that sending out these applications is something that is permitted by the statute?
And you've asked me two questions there, one about speech rights and one about the balance of powers between state and local government. So first is the speech rights of governments. The state cited the Garcetti case for the proposition that Mr. Hollins has no free speech rights. That case is inapplicable. It's about an employee of a district attorney's office not listening to his boss about what he can say. The state
I'm sorry, are you saying that the First Amendment authorizes the clerk to send this out?
I'm saying the First Amendment gives government officials, particularly a constitutional office, the right to say the government's point of view and the right to say the Harris County clerk's point of view. And secondly, within the balance of powers between state and local government, the office of the Attorney General is quite limited under the Texas Constitution. In fact, the office was curtailed in between the 1869 and the 1875 Constitution. And then let me shift back now, because I know my time is running short. With the code, I think if you read these individual sections, we win. A statute that says we have to give an application to someone if they ask doesn't prohibit implicitly giving it to people because we think it's a good management practice and it'll help make this election safe this November. And you also have to look at, and this court has said this before, look at the context in which things are enacted. In the Allcat case, the historic context of the Texas election code and the sometimes shameful history of Texas when it comes to voting rights. The language that became 8412 and 8413 was enacted in 1977 by State Representative Irma Rangel, the first Latina in the Texas legislature. She didn't do that to limit access to voting. One would suspect she did that because some courthouses had a habit back in the day of not giving every voter access to the information and the forms they needed to effectively exercise their franchise. And then look at the history of 110.
But before your time expires, or as your time expires, if I may, the state points out that section 1.010A talks about making the forms available, readily and timely available, making them available, whereas 1.010B and C refer to furnishing the forms upon request, and 84.012 also refers to furnishing or mailing, and then 84.013 to furnishing. And they say that we have to presume that the legislature intended different meanings when it used different terms, make available on the one hand and furnish on the other. You disagree with that, or do you agree but disagree with the meanings that they would give the two individual terms?
I agree that all statutes must be read together. I disagree with the state's conclusion on that. 1010B is similar to 84012. It's the floor. You may not deny a voter who asks ever. 1010A is a general statute. As I said before, there's a reason it's in Chapter 1, to make all voting forms readily and timely available. And look at when that was enacted. It was a pulling together of different statutes about form availabilities, enacted in 1985, which was when the modern election code was created, after a multi-year process, bipartisan process, to make voting easier. And I'll end with reminding this court of its decisions, both in Owens from 1885, that when in doubt, the voter wins. We encourage people to vote as the government. We do not put up hurdles for them. And secondly, back to the question of voter confusion, this court's decision in Ray Francis. There was discussion about when voter confusion, and the court should not presume voter confusion based on conjecture. The court should assume voters can read, which the state does not do in its arguments below or to the appellate courts. Voters have a right to information of how to vote legally, and to the forms to vote. And we cannot presume that everybody can go buy their groceries. Many get their delivery from HEB, and we've got to handle those voters as well so they have access to vote this fall.
Counsel, have these applications, these 2.3 million applications, already been printed?
That number is inaccurate. The state keeps saying millions. And let me break that down and go through the history. Again, in June, they were sent to voters over 65. That was very successful from a management and conduct of the election point of view. The state sued on August 31st. And if you look at the petition, it wants to stop all of the applications. The state agreed in a Rule 11 agreement that afternoon that they could go out to voters over 65. Those went, they numbered a few 100,000. I think now when you take out the over 65 and voters who have already asked for a ballot by mail, the mailer is something around 1.7, 1.8 million. They had not been printed at the time of the lawsuit was just filed. The county had, the clerk's office has started printing them.
Ms.
As we've
Hayes.
explained to this court, it will take
Hayes.
3 weeks to get them all printed.
Have they all been printed now?
They have not all been printed now. They're in process. And it's a two waves of printing. You have to print them and then run them back through to personalize them and put the barcode and the number on them.
Chief Justice, may I ask a question?
Yeah,
to Ms.
Justice
Hayes? Ms. Hayes, what does that 1.7 million number correlate to? How did you come up with that?
You take the total registered voters in the county, and then you take out the 65 and up, those have already gone out, and then you take out the number of those under 65 who have already requested a ballot by mail.
So you're sending a ballot to everyone in Harris County who's registered?
Who hasn't already requested.
Right, okay.
And as y'all may have seen, the requests are up dramatically. We are already up to over 200,000, and that's about double what it typically is in a presidential general year election.
Thank you, Ms. Hayes.
Judge, I have one question.
Yes, Justice Dunn.
Are the election judges being excluded from the 11 annexes that are right now receiving early ballots?
Election judges?
Yes. People monitoring the legitimacy of those ballots that are coming in.
This is, of course, way outside the record in the case, but I did look into this yesterday. Poll watchers have been there for a couple of days. And I believe yesterday morning, the Secretary of State sent out an email saying poll watchers could not come into those locations because they're not polling places. frankly, I don't understand why they couldn't be in a public office building.
Any other questions?
Chief, could I ask just one
Yes,
question,
Justice
please?
Lerman.
So, Ms. Hayes, what is your answer to their argument that some things are available for the clerks to provide, such as air conditioning or other things that are necessary for voting to occur, but other things are not unless they're specifically in the statute? What's your answer to that?
It's an unworkable analysis of the election code. How do you put on an event as detailed, as regulated, and as massive as conducting an election in Harris County without the authority? And I think it is specifically allowed within management and those words, management and conduct, but also implied within those bounds to do everything you can to make voting accessible practically to all eligible voters in the election. And I think it's perverse for the state to come in and say, you can keep the room comfortable, but you can't give people applications to vote by mail and let them decide for themselves, as this court said they could in Ray State, whether they're eligible, read the instructions, and send that application in so they can vote and vote safely this election.
Any other questions? Thank you, Ms. Hayes. General Hawkins, you have 5 minutes for rebuttal.
Thank you, Mr. Chief Justice. I think the Chief Justice's line of inquiry is exactly right. The legislature does not want widespread chaos and differences from one county to the next. The legislature has indicated that it prefers uniformity in the conduct of the state's elections. Ms. Hayes a moment ago admitted that her view of the powers of county clerks would lead to wildly different practices from county to county, contrary to what the legislature intends. I think there's another concern that her argument raises, which is that the legislature throughout Chapter 84, and indeed throughout the entire election code, has painstakingly crafted a set of rules and regulations regarding the conduct of elections. It's spelled out in painstaking detail that we don't see in other areas of the law. If she were correct that the county clerks could do whatever seems like good policy at any given moment, there would have been no need for the legislature to do all of that. And I think that that's a clue that her reading of the law is incorrect. I also want to address the parade of horribles that she brings up. There is no parade. She mentioned specifically the example of moving the main polling location, I believe, and she said that the legislature hasn't spoken to that. But I think she's overlooking Section 85.002B, which specifically speaks to that issue and gives counties the authorization to do things like that under certain circumstances. So it's just not true that the legislature hasn't thought of this at all. She indicated that we conceded below that the mailer that Mr. Hollins put together, I believe she used the word laudable. That's simply not true. We did indicate below that Mr. Hollins's proposed mailer is less inaccurate than some other information floating around out there, but we've never conceded that it's laudable. We've never conceded it's correct. Indeed, it's misleading for the reasons that we got into earlier.
Chair Hawkins?
Yes, Your Honor.
If I may, she also mentioned Section 31005, which you did not have time to address in your opening argument. And I have a specific question about that just to help me understand the state's position here. 31005B says that, well, A and B says that the Secretary of State acting through the Attorney General can take action to prevent certain things. And what it specifically says is that if the state determines that an official is exercising the powers vested in that person in a manner that impedes the free exercise of a citizen's voting rights, then the state may take action. And to me, that seems to comprise two separate requirements. One is first off, the clerk has to have powers, has to be exercising powers that are vested in that person. And that's been what I understand to be your argument, that that the clerk here is exercising powers that are not vested in the clerk. But even if we concluded that these powers were vested in the clerk, I think what 31005 says is you could still try to stop it if they are exercising those powers in a way that impedes the free exercise of voting rights. I just want to make sure, number one, that I correctly understand you're not taking the position in this case that we should prevent this activity based on 31005 because it impedes the free exercise of a citizen's voting rights. I haven't seen that in your pleadings.
That's correct, Justice Boyd. This is an ultra vires action by the state, by and through Attorney General Paxton. The Secretary of State is not a party, and we're not invoking 31.005 before this court. If I could just, I guess, close with one final point. I think it's worth noting that what the county clerk seeks to do here is unprecedented as far as we can tell. We don't believe this has ever happened before. If it were indeed the case, as Ms. Hayes insists, that it's necessarily implied that clerks should be doing this to effectuate the powers they've been granted, I think we would have seen this happen before, but we haven't. And I think that undercuts her argument. And that, I think, goes to why this is such an important case. If Hollins's actions are allowed to proceed, it will fundamentally upset the balance of power between the states and counties. That conception of power has existed for a century. I see I'm out of time. Unless the court has any further questions, we would ask the court to hold we're entitled to injunctive relief.
Chief, I just have one quick, well, go ahead. Go ahead,
Justice Devine.
Yes, according to your opposing counsel, these applications are in the process of being printed. Should you win in your argument, will you seek to have these applications impounded?
Your Honor, what we sought in the trial court is an order enjoining them from being sent out. I guess all I would say in response to that is that the state will take whatever action necessary to enforce any injunction that should issue from the court.
Justice Lehrman.
In response to your statement earlier that this has never happened before, have applications been sent out to all persons over 65 before this past summer?
I don't believe, Justice Lehrman, the record speaks to that. Even if that had happened in previous elections, though, we have never seen what we're seeing here, where mail-in applications to vote by mail are being sent en masse, hundreds of thousands or even millions, to people who have never asked for them and are probably not eligible to vote by mail.
Any other questions? Thank you, General Hawkins. Case is submitted and the marshal will adjourn the court.
Oh, yay, oh, yay, oh, yay. The Honorable, the Supreme Court of Texas now stands adjourned.